Oh, I absolutely think these challenges are going to continue to go forward. And I think whether they're successful or not remains to be seen. And, how quickly, for example, the Supreme Court actually weighs in on the substance and the merits of some of these decisions remains to be seen. But these cases are not going to go away, instantaneously just because of this decision from a few days ago. The plaintiffs are going to continue to kind of adapt and fight and press their substantive arguments about the constitutionality and legality of these policies. And we'll see kind of how those challenges proceed, through the federal court system here in the U.S.
Hello and welcome to the Trump Report. I'm Louis Sykes. Today we're going to be talking to Adam Steinman, Professor of Law at Texas A&M University Law School, and we're going to be discussing that legal decision last week by the Supreme Court that limits the abilities of federal courts to step in and stop some of Trump's executive orders and other decisions by the Trump administration. Remember, if you're listening to us, you can get us as a podcast, but you can also, if you're watching us, you can get us on YouTube, and you can sign up for a membership to our YouTube channel, or you can subscribe to our channel as well. It's the Trump Report for Times Radio. Professor Steinman, welcome.
Thank you so much. Thanks for having me.
Well, it's been just over a week since the Supreme Court quite severely restricted the capabilities of federal courts to issue nationwide injunctions on things like executive orders by the president. I want to get into what the impact has been so far, but firstly, what exactly is that decision the Supreme Court has made?
Yeah, so this is a decision called Trump versus CASA. And the case involved Trump's executive order on birthright citizenship. That was an order that declared that it is the policy of the United States to deny citizenship even to persons born in the United States in certain situations where the parents were in the U.S. either unlawfully or even temporarily, like on a student visa. This prompted several lawsuits to be filed in federal court, particularly by parents whose children might be denied citizenship under the policy. Some state governments were also plaintiffs in the case. And they challenged the policy as a violation of the 14th Amendment to the U.S. Constitution, which provides in fairly clear text that all persons born in the United States and subject to the jurisdiction thereof are citizens of the United States. So these cases in the U.S. start out in the trial courts. In the federal system, they're called the district courts. And the district courts in these cases, I think there were three of them, agreed with the plaintiffs, and they issued what is often called a universal injunction. So basically, an injunction saying that the policy denying birthright citizenship is unconstitutional, and therefore the Trump administration may not implement that policy of denying citizenship to children born in the United States. So, this injunction is called universal in the sense that it forbids the executive branch from denying birthright citizenship to anyone. So not just with respect to the individuals who filed the lawsuits. But, and this may be a bit of a tangent, even that name, universal injunction, makes it sound a little more radical than it actually is. Sometimes I like to call these just a compliance injunction. All it's doing is ordering Trump to abide by the law, namely the Constitution. And the courts, when they issue these kinds of rulings, is just saying the president can't go on violating the law with respect to every other child born in the United States just because they haven't filed their own lawsuit. So what goes to the Supreme Court is not actually the merits of that birthright citizenship issue. So nothing the court said agreed with Trump that he can deny citizenship to those born in the United States. What a 6-3 majority opinion said was that the particular foundational statute about the authority of the federal courts, it's called the Judiciary Act of 1789, does not give federal courts authority to issue these so-called universal injunctions or nationwide injunctions, even if the policy by which the executive branch is acting is patently unconstitutional. Instead, what the court said was an injunction can't be any broader than necessary to give complete relief to each plaintiff in the case that has standing to sue. And so what that means as a practical matter, and what the Supreme Court did was sent the case back down to these lower courts, But what it means is that the individual parents who filed the lawsuits can get an order requiring the Trump administration to recognize the citizenship of their children. But the federal court can't automatically stop Trump from denying citizenship to every other child born in the United States, even though the lower courts have found that that's unconstitutional.
Trump's response to this was to sort of say that this would make it easier for him to get his political agenda and some of those executive orders through. Is that accurate? Is there this wider impact? And if so, what has the impact been so far? Has it made it easier for Trump and the current administration to issue executive orders or get laws passed?
Well, there's nothing stopping Trump from issuing whatever executive order he wants to, right? The real question is, what are the federal courts empowered to do when those orders violate the law, whether it's the Constitution or the governing statutes, right? So absolutely, this ruling has taken an important weapon out of the arsenal of the federal courts. But it remains to be seen exactly how litigation in these kinds of cases is going to unfold. And the Supreme Court, as you know, potentially troubling as this decision is, did not necessarily close every door to allowing the federal courts to not only decide the merits, the substantive merits of whether a particular order is constitutional, but also provide a remedy, provide relief that will protect individuals who might be subjected to that illegal, unconstitutional order.
And so, does this then leave a lot of the power over the legal decisions made about a lot of Trump's agenda just with the Supreme Court? I mean, and if so, does it mean that it will actually give him more? It will be easier for him to get these things through, because he hasn't really had the Supreme Court in lockstep behind him, despite there being a majority of conservative judges, has he?
That's exactly right. Now, he's won his fair share at the Supreme Court, but frankly, a lot of these issues, for the huge number of cases that have been filed, against the Trump administration since his second term began, the Supreme Court has not yet had the opportunity to weigh in on the substantive merits of whether or not these various policies are or not constitutional. So the Supreme Court sits at the top of the judicial pyramid in the United States. And it's certainly taken advantage of a lot of opportunities to get involved in cases earlier than it might otherwise. But it really remains to be seen how many of these cases are going to percolate up and how quickly they're going to percolate up. And just to think about what might be going on in cases like the birthright citizenship case, now that we've had this decision from the Supreme Court, and this may apply to a number of other challenges that are going on against the Trump administration, is that plaintiffs and their lawyers are going to take advantage of some of these routes that the Supreme Court potentially left open. So one of those is something called a class action. So that decision in Trump versus Casa did not rule out the possibility of getting some kind of across-the-board injunctive relief if a class action is certified. Now, the way class actions work is you have one or more individual plaintiffs. Maybe they're these parents in the birthright citizenship case. They had proceeded initially as individual litigants, but they can ask those same federal courts, the lower federal courts that gave them the injunctive relief to begin with, they can now ask the court to certify a class that would include all other similarly situated individuals. And the way class actions work, you don't have to list all those individuals by name, right? It can be defined generically. And if that class is approved, then the result of the litigation will inure to the benefit of everyone who falls in that category. And that could potentially justify one of these compliance injunctions, one of these universal injunctions, because that's the only way to protect the entire class. Now, that's an additional step. It can be a cumbersome step. And it's one that certainly, at least according to the three dissenting justices in the Casa case, they argue this should not be necessary in all cases. There should be statutory authority recognized for federal courts to give these kind of individual injunction or universal injunctions, even in an individual case that's not certified as a class action. But I'm sure the plaintiffs in the birthright citizenship case will try to pursue that route, persuade the trial court to provisionally certify a class action, and grant at least preliminary injunctive relief for the benefit of that whole class. And if all those boxes are checked, the case can potentially proceed as it otherwise would, Then the question becomes, as you've suggested, how aggressively is the Supreme Court going to want to get involved in those decisions? Because obviously the Trump administration won't be happy about that if the district court certifies a class action and gives that kind of universal relief that a class action would warrant. But it's going to have to persuade the Supreme Court to get involved in that issue as well. It's not exactly clear what they'll do. They may not want to get involved in all of these issues, or at least not enough justices want to get involved to micromanage that process. But that very much remains to be seen, and that's likely the next step in some of these cases.
And so, where does that leave some of these efforts to halt or delay executive orders and laws put down by the Trump administration for further legal debate? Are there other paths available for lower courts, or is it just that class action route that you've outlined there?
Yeah, so that's one of the main ones. Another one that the court recognized, and even the majority recognized in the footnote, is there's a special statute called the Administrative Procedure Act. And one of the things it allows federal courts to do, I think the exact language is that it can hold unlawful and set aside agency action, right? And so, well, if the federal court can set aside the entire action, right, set aside some kind of policy adopted by an agency, then that potentially takes away its legal effect across the board. It's a nullity. Now, that one didn't technically apply in Trump versus CASA because the Administrative Procedure Act doesn't apply to the president. It applies to the executive branch officials and the agencies that the president oversees. And some of the challenges to Trump's policies do involve agency actions, and they are likely to, perhaps in addition to pursuing the class action route, try to wrap themselves in the authority given to federal courts under this Administrative Procedure Act provision. And even on the birthright citizenship case, right now we just have this statement by the president of what he is saying is the policy of the United States. But ultimately, it's going to have to be implemented by agencies, whether it's the Secretary of State, Social Security Administration, other agencies, and that might open the door to challenges that are going to invoke that statute. And again, the court in the CASA case did not explicitly endorse that as a statutory source for granting this kind of universal injunctive relief, but it didn't rule it out. So kind of like with the class actions, the next step after that might be how much does the Supreme Court want to now get involved in that issue? Because it has discretion. The Supreme Court has, in the vast majority of cases, complete discretion whether to take the case, and certainly complete discretion whether to act aggressively in getting the case early. Because in the mine run of cases in the federal courts, it takes a long time to get to the Supreme Court. You have to wait through the process in the trial court. You have to wait till there's a final judgment in the trial court. And then you have to appeal to the intermediate appellate court. You've probably been following some of these decisions by the circuits. We've got these numbered appellate circuits in the US, the Fourth Circuit, the Ninth Circuit, the Second Circuit. Usually you've got to go through those decisions first. And only then, and that could take months, if not a year or more, to get a decision from the appellate court. Usually, the Supreme Court sits by and lets that process unfold, lets that process percolate, and then takes the case. But this so-called shadow docket is a method that allows the court to take these cases much earlier, usually under the umbrella of some of these emergency motions that can get filed. And when it has the will, when it has the votes, it can get involved much earlier. So it remains to be seen whether they're going to want to answer some of these unanswered questions regarding the ability of courts to give more universal relief through these various other mechanisms.
You mentioned earlier the dissents by some of the Supreme Court judges on this decision. There was voicing there of concern about the balance of power. Is there concern around this decision about the checks and balances on the position of the president in the US?
I think there certainly is. At least for 100 years, if not more, these kinds of universal injunctions have been something that has been in the federal court's toolbox. And even though these other mechanisms are available, they're not as easy to achieve as what federal courts had been doing through these sorts of compliance or universal injunctions. So it's certainly, to the extent checks and balances are sort of a zero-sum game, right? When you take power away from one branch, it gives more power to the other branch. This is something that has swung the pendulum back towards the executive branch. But like we've been talking about, there may be some mechanisms that will enable federal courts to do their traditional job in both interpreting and applying the Constitution and other federal laws, and then providing needed relief to ensure that the laws are followed. So I don't want to sugarcoat this opinion, but I also don't want to claim that the sky is falling, because sometimes that can sort of bring about the worst possible outcome almost as a self-fulfilling prophecy. And I certainly don't want to discourage, plaintiffs who are challenging these policies on valid grounds from pursuing all of the mechanisms that are still available to permit the federal courts to fulfill their role in our checks and balances.
And speaking to the press after this decision, Trump really wanted to make out that this was effectively just kind of bureaucracy or legally pushed through decisions that have been blocking him from getting some of these laws into law, or policies into law. Is he right in saying that? Is Trump completely out of the woods on this, or actually is there still some pretty significant challenge left to his policy agenda?
Oh, I absolutely think these challenges are going to continue to go forward. And I think whether they're successful or not remains to be seen. And, how quickly, for example, the Supreme Court actually weighs in on the substance and the merits of some of these decisions remains to be seen. But these cases are not going to go away, instantaneously just because of this decision from a few days ago. The plaintiffs are going to continue to kind of adapt and fight and press their substantive arguments about the constitutionality and legality of these policies. And we'll see kind of how those challenges proceed, through the federal court system here in the U.S.
And you mentioned at the start of this interview, a lot of this has come off the back of Trump's executive order trying to end birthright citizenship in the US. Is that then all but assured to happen now?
Certainly not, right? So there's a 30-day delay in terms of that policy actually going into effect. And it would not surprise me at all if before those 30 days have elapsed, the plaintiffs have followed one of these alternative mechanisms in the district court on remand from the Supreme Court decision, and have obtained some kind of universal preliminary injunction or temporary restraining order through something like a class action. If that happens, then things are going to remain on hold. And again, we'll see how aggressively the Trump administration wants to push it up through the appellate system in the U.S. And the plaintiffs might not automatically win, but I think certainly it's a possibility, and we'll see how the courts at various levels of the judiciary handle those kinds of arguments.
And just to give our audience an understanding, because the UK does not have birthright citizenship, although it's a relatively self-explanatory idea. But how significant is birthright citizenship in the US, and what sort of a change would that be for the US to not have that system anymore?
Well, I'm not an immigration specialist, but it's certainly a big part of what I was raised to understand America to be. It's been a part of our Constitution since the 14th Amendment back in the 1860s, and it would certainly be a big change to how citizenship is determined in the United States. It would certainly open up a big can of worms in terms of just the procedures and that would have to be followed in order to assess the citizenship of anyone born in the United States. And it is obviously very much counter to the text of the 14th Amendment. And I think folks who I know who specialize in these sorts of issues as a matter of immigration law are pretty confident that on the substance, this kind of undermining of birthright citizenship is not going to pass muster constitutionally. And it may be telling that, taking us back to the Trump v. Casa decision, the Trump administration could have made one of the issues for the Supreme Court to decide that constitutional question. Does the 14th Amendment allow the president to take away birthright citizenship, didn't do that. It instead focused on this question of the permissibility of these so-called universal injunctions. And it may have realized that if it had pushed aggressively its substantive 14th Amendment argument, that it would have lost. And so now it gets to sort of claim a partial victory, but that substantive constitutional question is still very much to be decided.
And I appreciate, of course, that no one can be an expert in all of the legal challenges that Donald Trump is and his administration are facing on that pretty wide plethora of executive orders and the policy agenda Trump is trying to lay out. But what is the wider impact of this Supreme Court decision on the law surrounding Trump's administrative policies?
Yeah, so it's certainly going to make it harder to bring these kinds of lawsuits, right? Many plaintiffs will have to now go through this additional step of trying to get a class action certified, but they have smart lawyers. They know how that class certification process works. And I will say, class actions have sometimes run into obstacles in the federal courts, but the vast majority of those cases are class actions for money damages. And one of the things that federal courts have pushed back on is a concern where there might be a lot of individualized issues in a class action like that. How much damages is one class member owed as opposed to another? The presence of a lot of individualized issues is one of the things that makes it unlikely for a class action to be certified. But most of these challenges present single, pure, clean legal issues. There's no individualized question to sort out about whether birthright citizenship is constitutional. So there's certainly an argument that class actions are very much appropriate in those kinds of cases. With respect to others, we'll see. Certainly there are some cases, a lot of the ones challenging some of the, whether it's budget cuts or employee cuts at the federal government level, those have fit within the Administrative Procedure Act rubric and therefore might be able to take advantage of this statutory provision that I mentioned earlier. But lawyers are cautious. Lawyers sometimes take a belt and suspenders approach. So a lot of those cases may soon be transformed into class actions. But these are all things that litigants are now going to be having to deal with in the wake of this Trump versus Casa decision. And as I've said, it sound like a broken record, but we'll sort of see what happens as the courts are required to sink their teeth into these remedial and procedural issues.
Well, Professor Steinman, as you say, there is a lot to be seen on this and a lot more developments I'm sure we'll expect. So hopefully we'll speak to you about them again soon. Adam Steinman, Professor of Law at Texas A&M University Law School, thank you very much for joining me today on the Trump Report.
Thanks so much. It's been a pleasure. Thanks.